Today, former President Donald Trump's lawyers filed a motion to dismiss Trump's 4-count indictment. This indictment arises out of the events of January 6, 2021 at the U.S. Capitol, which is, incidentally, just 2 blocks from the federal courthouse, where the president is set to stand trial in March. The motion to dismiss argues that the president's indictment should be dismissed on the grounds of presidential immunity. The pleading states in part that under the separation of powers clause in the Constitution, any action taken against the president must be done by impeachment in the House, followed by a trial in the Senate, and not in a federal criminal court. Obviously, the federal court is in the judicial branch of government, and the Senate and the House are in the legislative branch. An almost 50-page motion to dismiss, which will no doubt be opposed by Special Counsel Jack Smith, will be decided first by the trial court judge, Federal District Court Judge Tanya Chutkan. And the losing party will seek appeal of that decision in the United States Court of Appeals for the D.C. Circuit. And as a piece of legal trivia, that is the appellate court where now Attorney General Merrick Garland sat for 24 years before being named by President Biden as the United States Attorney General. Harvard Law Professor Emeritus and author of the book Get Trump, Alan Dershowitz, joins me. Good evening, sir. And the motion, obviously, Judge Chutkan is not a big fan of President Trump. She's not been very, I think, the fact that she scheduled a trial with 12.8 million documents for March 3rd is grossly unfair. But turning that aside, is that if President Trump loses his motion to dismiss, and I anticipate that, can he appeal now, or does he have to wait till after trial?
Well, he can try to appeal because it raises constitutional issues. But the traditional rule is that if you lose a motion to dismiss, you have to wait until you've been convicted. Now, the Constitution does explicitly provide that after a president's been impeached, they can still be tried. So I don't see that this motion has any substantial chance of prevailing, certainly not in front of this judge. And I doubt that the Court of Appeals will want to take that issue up before trial. But because it's a constitutional issue and because we've never had a situation like this in our history, all bets are off and all precedents are irrelevant. So it's possible that the court may take this up. But if I'm pretty good at predicting. My prediction is the motion will lose and the appellate court will not review it immediately, but will review it later if there's conviction.
And then, of course, if the losing party, which I presume would be President Trump here, is that on this particular issue, is that they will have to get permissions, seek cert from the Supreme Court. It's not an automatic appeal, right?
It's not an automatic appeal, and cert is unlikely if the Court of Appeals says it's too early. We're not going to consider this motion now. That's usually a signal to the Supreme Court to wait. But remember, too, if I were Trump's lawyers, I would argue the whole strategy behind this kind of Get Trump movement is to try to get convictions now before the election, knowing that they may very well be reversed after the election is over, and that the court shouldn't play a role in that. And therefore, the court should take an appeal on this issue before the election to thwart the improper tactic of the other side to try to get a down and dirty conviction.
You know,
well that it might be reversed late.
You know what I would do if I were the trial lawyer? And of course, we lawyers always second guess each other. I would file a motion to withdraw from representing Trump based on the fact that having to read 12.8 million documents before March 3rd trial, or even before the October 9th date for pretrial motions, which is, December, I think there's now pretrial motions, is impossible. It's just absolutely impossible. And so that she's forcing any lawyer to render ineffective assistance of counsel when you have a right to counsel at trial. I'd file a motion to withdraw because I think it's impossible to be ready for this trial as a defense lawyer.
I completely agree with you. I wouldn't do it in the form of a motion to withdraw, though. I would say to the court, sorry, Your Honor, I cannot defend this defendant, and neither can anybody else. And if you order me to defend this case, you'll be ordering me to commit a malpractice. Now, the judge has already said, oh, you don't have to reread all those 25.
She's nuts. Come on. Come on. That's patently, and she's a former federal defender. She knows better. That's a lie. Any lawyer who doesn't read every document is,
Plus, she's a federal defender that she doesn't know better, because often federal defenders don't have the time to read everything, and they do skim things, and they do take shortcuts. It's not their fault. They're great lawyers, and they have their hearts and souls in it. but they don't have the time or the resources to read everything. But I'm not that kind of lawyer, and you're not that kind of lawyer. And I have to tell you, I would not appear in front of a court that demanded of me that I try a case as an incompetent, ineffective lawyer. I just wouldn't do it. You might do it in the form of law. I would do it by simply refusing and saying nobody should be forced to try this case under these circumstances. I would make the same argument in Georgia.
I would. That's why I would say I'd file a motion to withdraw, because I think it's deplorable, because there's no way a good lawyer can be ready. And he has good lawyers, I should add. Alan Dershowitz, thank you, sir.
Thank you.